NACDL is the association of the nation's criminal defense bar.
My goal in this talk to you today is to bring you up to date on how courts have applied the landmark location tracking case Carpenter versus United States. When the case came out, everyone agreed it was a landmark, but also that it left a ton of unanswered questions. It has been nearly 4 years since the decision came out, and lower courts and state Supreme Courts have made a lot of progress starting to apply the case to new technological contexts. And I want to talk about some of those cases with you today. There's a handout that there's a lot of sort of case sites in this talk. There's a handout that has them all. The one in the packet is old. That will be updated, but you can also access the handout on my publications page on my Berkeley Law faculty website. So I'm just going to talk briefly about Carpenter because with a crowd like this, I know you all know this. So as you will recall, federal agents suspected Timothy Carpenter of robbing a series of electronics stores, ironically cell phone stores. And so they requested cell site location information from his mobile carriers, and they got 129 days worth of data. And the Supreme Court ruled that the government must typically obtain a search warrant before accessing people's cell site location information, their historical cell site location information, at least for periods of 7 days or longer. The Supreme Court did not give a ton of guidance for future cases, but it did outline some factors that were relevant to its decision, specifically the revealing nature of location data, the quantity of data, the number of people affected, the inescapable and automatic nature of data collection, and the incredibly low cost of tracking people through their cell phones. So more concretely, we know after Carpenter from the Supreme Court that 7 or more days of historical CSLI is a search, but there's a lot we don't know. We don't know about fewer than 7 days of CSLI. We don't know about real-time cell phone location tracking, whether that will require a warrant. We don't know about tower dumps. Will that require a warrant when law enforcement wants to download all of the information about devices connected to a particular cell phone tower at a particular time? The court said, we do not disturb Smith and Miller, which are the dialed telephone numbers and bank records cases, saying that you voluntarily disclosed those to third parties and therefore no privacy interests. So that was a little puzzling given the overall holding. And then they said conventional surveillance techniques and tools, such as security cameras, we're of course not disturbing that. So a lot of unanswered questions. Let's take a look at how lower courts have started to try to resolve them. And I'm just going to try to point out some useful decisions to you on these various areas. So one, historical cell site location information. Not a lot of courts have weighed in on whether fewer than 7 days of historical information is a search, but there's a helpful decision actually on federal Fourth Amendment grounds from the wonderful path-breaking Massachusetts High State Court, the Supreme Judicial Court, saying that when officers collect more than 6 hours of cell site location information, that requires a warrant under Carpenter. So if you're looking for something to cite for that, that's one place to go. Real-time cell site location information. The Supreme Court expressly said it wasn't reaching this question, but in recent years, a number of state Supreme Courts have reached it and have said that essentially the rationale of Carpenter, that widespread continuous gathering of location data implicates privacy interests. So for example, in Commonwealth versus Pacheco, law enforcement obtained 108 days of location tracking data of someone suspected of drug trafficking. And particularly given that long duration of tracking, Pennsylvania Supreme Court said it had no trouble concluding that type of real-time tracking, which also creates a comprehensive records of someone's movement, should require a warrant. If you aren't lucky enough to have 108 days of real cell site location information data, you might take a look at State versus Muhammad from the Washington State Supreme Court, again, also decided on federal Fourth Amendment grounds, which said that a single ping of real-time location data triggered the warrant requirement. And it essentially said that it didn't think that the line drawing exercise was going to be anything but arbitrary. How do you distinguish between 7 days versus 6 hours versus anything else? And so they just established the bright line rule that real-time cell phone location tracking data would require a warrant. The next context are pole cameras, right? These are cameras attached typically to utility poles and focused on homes. And one question that courts have addressed is whether long-term observation of a home is a search requiring a warrant under Carpenter. So some courts, actually a fair number, have concluded that this is not a search under Carpenter. So for example, most recently, I think in Tuggle, the Seventh Circuit concluded that even though there were 18 months of 3 different cameras focused on areas near the home, this just wasn't a search. And it emphasized that these cameras were only picking up the public streets in front of the house. In contrast, in People versus Tafoya, the Colorado Supreme Court concluded that using a pole camera to specifically examine the curtilage of someone's house for 3 months required a warrant based on a probable cause warrant. So in this case, the camera was actually specifically angled down from a high location to look at what was happening in someone's backyard. And the court said, hey, but you're having a comprehensive record of someone's activities in their home. It's recording everyone who comes and goes from the house, therefore gaining insights into someone's association. You also see every time this person leaves or enters their own home. And it said, it stressed that the home is first among equals and whose historical significance should not be overlooked when it comes to the Fourth Amendment. So moving on to vehicle location data, some courts have either revisited car GPS tracking after Carpenter, specifically in the context, sort of unlike in Jones, the majority in Jones held that because the Scalia opinion said that because the GPS device affixed to the vehicle in that case, it had a wire that went into the undercarriage of the car, and therefore there was a physical trespass on the car to gather information. That was a search. Other courts have subsequently relied on Carpenter to conclude that when you get GPS data through about a car's movements, that triggers the warrant requirement. So in United States versus Diggs, one district court concluded that when, so a defendant, they tracked a defendant through his car, they actually got the data because there's a GPS tracking device on the car because the car had been purchased with the help of a creditor who insisted on that device being installed. And even though the police went to the creditor and said, could I access the tracking data? And the creditor said yes. The court still concluded that there was a search and that the third-party doctrine didn't apply because of the intimate nature of the data that was collected. Not all courts have come out that way. So, for example, United States versus Howard concluded that when a GPS device was installed on a borrowed car for a shorter period of time, in this case 22 hours, it held that it wasn't invasive enough to trigger a warrant requirement. Tower dumps, this is when law enforcement gets information about all cell phones pinging a particular power at a particular time. So that question, again, was one that the Supreme Court said, we're definitely not reaching this question here. I just want to mention one case, Commonwealth versus Perry, and this one I'll just say was actually decided on state constitutional grounds. So in that case, the Massachusetts High Court said that the government needs a warrant based on probable cause when it wants to collect data from tower dumps under the circumstance that it did 7 tower dumps over 7 different days, and those days spanned a month. And the government says, hey, hang on a second. If you add all of the duration of these tower dumps together, it's only 3 hours, and that shouldn't be enough to trigger to trigger Carpenter, and the state Supreme Court came back and said, no, actually it does trigger Carpenter because the days were spread out. Even intermittent cell site location data over a prolonged period of time can reveal someone's movements and their associations and their patterns of life, and therefore you need a warrant. I will add that it rejected the argument that the defendant made that tower dumps are per se unconstitutional. The defendant had argued that because there was no way to particularize a tower dump, the government had to get access to all of the people who pinged the data, that the search was just, that the warrant was just fatally flawed. And the court said, no, when you analyze what the search is, it's not just downloading the data, it's also analyzing it. And because they only analyzed it for the one defendant, the search was adequately particularized. Geofence warrants. I'm going to say almost nothing about geofence warrants because there's an entire panel on this topic tomorrow. And the people on the panel actually litigated this case, United States versus Chatry, which is now the leading geofence warrants case. So this is a relatively recent decision out of the Eastern District of Washington. It's the only decision in which courts have weighed in on whether a geofence warrant violates the Fourth Amendment in the context of a suppression motion. So although other magistrates have weighed in at the stage where the government seeks the warrants and have come out varying directions. So in this case, and I should just back up and say, a geofence warrant specifically is when the government goes to Google and asks, or maybe another tech company, and asks for all of the geolocation data generated by phones using Google in a particular location at a particular time. In this case, law enforcement asked for Google to give it all the location data in an area that was a circle with a sort of 150-meter radius. And the court said that although it thought that the warrant plainly violated the Fourth Amendment because it didn't establish probable cause with particularity as to all of the targets in the zone, the warrant was nonetheless valid under the good faith exception to the exclusionary rule. You're going to hear a lot of fascinating details about that case tomorrow, so that's all I'm going to say about geofence warrants here. Automatic license plate reader. So you've heard about these devices earlier today too. This is when police set up cameras and take photos of every passing car. Those photos can be converted into machine-readable text and then searched, so you could either create a hot list of cars you're looking for in real time, for example, every car that's associated with someone with an outstanding arrest warrant, or you can save the data and search it retrospectively. In Commonwealth versus McCarthy, the specific factual scenario was that the law enforcement, the Supreme Judicial Court looked at the use of 4 ALPR machines that gathered information about the defendant over a 10-week period. And relying on Carpenter, it just held that those, just having those 4 specific data points didn't actually provide a rich enough picture of where the person had gone in order to trigger Carpenter's rule that a warrant would be required for location information. But it actually then went on to say that with enough cameras and enough historic location data from an ALPR system in Massachusetts would invade a reasonable expectation of privacy and would constitute a search for constitutional purposes. So in some ways, the court was suggesting that the claim was brought too early in a context when the technology wasn't sufficiently widespread, and that it would be open to a claim where the ALPR data created a richer picture of someone's movements. I just have a couple more examples. This case has one of my favorite names, Leaders of a Beautiful Struggle versus Baltimore Police Department. This is the Baltimore Police Department developed a sort of path-breaking surveillance program where they used, this is actually funded by a nonprofit organization rather than the city, one that does a lot of criminal justice system reform work. But in any event, in this case, they donated to the city so that the police could fly manned aircraft over a 33-mile zone of the city for 40 hours a day and record everything that happened. And this group, Leaders of a Beautiful Struggle, sued, saying that this was making a comprehensive map of the movements of everyone in this 33-mile area, and that violated the Fourth Amendment. And the en banc Fourth Circuit agreed, saying, like, this is clearly creating a detailed encyclopedic record of where everyone in this area is going every time they move outside, and therefore you need a warrant to engage in that type of surveillance, which the government did not have in this mass surveillance program. So I don't know where this model will go, but this decision was very useful. The final context I want to talk about is university card swipe data. I work at a university and have a card, so maybe this is just near and dear to my heart. But if you are a university student these days, you are issued a student ID, and you must use that student ID, generally speaking, to enter buildings, enter your dorm room, maybe use it to purchase food, to check out books at the library, so on and so forth. So the question is, when universities then access the location data those card swipes generate, because of course they're all recorded and stored, does that require them to get a warrant based on probable cause? And this case involved investigation of a hazing incident, and the court relied on the terms of service of the university ID to basically say, no, you agreed that we would be able to access this information for lawful purposes, and therefore whatever interests you might have from this under Carpenter are overcome by your consent. There's a similar case, actually, which deals with tracking of someone's connections to a campus Wi-Fi network, and it was the same outcome, specifically that because students had agreed in the terms of service that their location data could be stored, that overcame their Carpenter claim. Okay, so that is just a brief tour of where courts have gone with Carpenter. We've been trying to actually host this conference again in person for like 2 years, maybe 3 years, so it's great to be able to talk about this. So many of these opinions are actually since that last conference, so it's nice to highlight them. And again, if you ever want to talk about any of this, you can reach me at this contact information, and all of the case sites and additional citations to other cases are in the handout you received. So thank you.